It's Friday night, Halloween weekend, and I'm Nate Eaton, still at work, about to head home. Actually, I was on my way out the door when I got word that we have some new developments in the Daybell case. Wanted to fill you in quickly. Chad Daybell's case has officially been continued. It will not be happening in Boise, in Ada County, in January. Judge Boyce filed a response to John Pryor's motion to have the trial in January, or his motion to continue it, to have it delayed. Boyce responded today late this evening, and that is what's going to happen. Judge Boyce has granted the motion to delay the trial. We don't have a new date yet. He's going to meet with the attorneys, the prosecutors and Pryor, to see when they can come up with a new date. He did say in his motion, so John Pryor had filed this motion saying that there's a significant amount of evidence that he still needs to go through. Pryor said, I can be ready for the trial, but it would be preferred if I can wait, if we can push it off. And so the judge decided that, yes, we're going to let you push it off. Let me find it here in these documents that I just got. Here we have, despite the preparations, the court has already taken a considerable time and expense, including multiple on-site visits and coordination efforts with Ada County, wherein counsel for the parties have also been present. To hold this trial in January, the trial must be vacated and continued. Having previously established that the defendant has waived his right to a speedy trial, the court must ensure that the defendant has a full and meaningful opportunity to prepare a defense. The court will contact counsel to reschedule the trial. The court expects counsel for the parties to have a full and complete understanding of what preparations remain in rescheduling the trial so as to avoid any unnecessary delay in the administration of the case. Judge Boyce is basically saying, all right, I've got to do this because you've asked for it, and the defendant deserves his right to a fair trial, but, be ready. We got to be ready when this new date is set. Of course, this trial has been moved across the state to Ada County from Fremont County. It's about a 5-hour drive, so there's a lot of coordination to reserve a courtroom for up to 10 weeks, have a jury, all that, and it was supposed to begin here in about 8 weeks, beginning of January 9th. And now that will no longer happen. So what happens with Lori? Well, that's the question. Her case remains on hold while the judge and the court works to determine her competency. Everything's been frozen, basically. As of now, their trials are still going to be held together, we assume. Nothing's changed in that matter. If Lori is found competent next week, beginning of January, even February, you could assume that it'll pick right back up and they'll go to trial together. But come April, May, June, or whenever this trial is going to be scheduled, if it gets close and she's not competent, then Chad will obviously have a trial on his own. All that needs to be worked out. Again, we don't have a new date for Chad's trial. The attorneys are going to get together, come up with that. Of course, John Pryor has filed a motion to sever and separate these trials from one another. He will argue that motion in November. There'll be a date where he will argue that motion. We'll see what the prosecutors say. The prosecutors did not object to this continuance. They basically said as long as these trials are held together, we're fine. They don't want to do two separate trials. So we've got a full story up on eastidahonews.com going into the year number 4 of this, right? Because this happened in January of 2020 when we went to Hawaii. All of 2020, all of 21, all of 22, now going into 2023. So I wanted to update you all, let you know that that is the latest. We'll have a full story on it, and we wait to see what happens. See ya.